All right, good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I am sitting on this case this morning with Judge Mall and Judge Pellegrino. Judge Pellegrino cannot join us for this argument, so it'll be conducted before just myself and Judge Mall. Judge Pellegrino has reviewed the briefs and the record and will listen or watch the argument before participating in deliberations. This argument is being conducted over the Teams platform, so everyone is appearing via video. I'm going to ask everyone to introduce themselves. I'll start with the judges and then counsel for the appellant and counsel for the appellee to make sure we can all hear and see each other okay. I'm Judge Bright.
Good morning, I'm Judge Mall.
Good morning, everyone. James B. Strito for the defendant appellant, Charles Gamer from the Office of the Chief Public Defender's Legal Services Unit.
Good morning, Your Honors. I'm Lori Feldman, a Deputy Assistant State's Attorney representing the people of the state of Connecticut.
All right, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you're unable to hear anyone or see anyone, please let us know. If we have to, we can pause the video to correct any difficulties. And if anyone gets kicked off, we will pause until everyone is back on. Other than that, this will be just like an argument in the court. I think both of you have done these video arguments before. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. And this is, I think I already said State versus Gamer, docket number 44179. Attorney Streeter, are you ready to proceed?
I'm ready, Your Honor, and may it please the court. As mentioned, James B. Strito from the Office of the Chief Public Defender's Legal Services Unit for the appellant, Charles Gamer. May I reserve 5 minutes of rebuttal time, Your Honor?
Sure, and I will keep the time and hold up signs at 2 minutes, 1 minute when your time is up, okay?
Thank you very much. Your Honors, I'd be remiss if I did not begin by thanking both the court and opposing counsel for your flexibility in going virtual. I made this request earlier. I had kept everybody in the loop. We got back from vacation, and due to the constraints of COVID testing, I didn't get a negative COVID test until very early this morning, which was actually sooner than I'd expected. And I didn't want to expose anyone to the possibility I might have COVID. Your Honors, this case is not about whether the defendant failed to pay restitution. Trial counsel conceded that at sentencing. And given the disparity between the amount the defendant was able to pay and the actual restitution order, no other conclusion would have been reasonable. Rather, it's about whether he failed to pay restitution through no fault of his own, but through the constraints of being a 57-year-old man in an extremely difficult job market with a serious felony conviction, or whether he failed to pay it willfully. In that sense, this case is governed by both Bearden and by this court's recent decision in Parker. Parker lays out...
Stop you there for a moment, Attorney Strito. So both Bearden and Parker dealt primarily with the issue of whether the court made the finding of willfulness. Do you dispute that the trial court here made a finding that the failure to pay was willful?
We do not, Your Honor. The trial court did, in fact, make a finding that the defendant willfully failed to pay. It's actually in the appendix to the brief, and I'm going to refer to it specifically. But the trial court isn't clear as to whether the trial court is finding under the first Bearden prong that the defendant had the wherewithal to pay, or under the second that he lacked the ability to pay but failed to make sufficient bona fide efforts to acquire it. However, given her statement on page A198 of the record of my appendix, that the $200,000 was gone and that Mr. Gamer spent the money, we know we no longer have it. It would seem to be that her finding is under the insufficient efforts prong.
Yeah, and I think she said that at the first hearing. I'm just trying to get to that in the appendix. It's around page 162 or 63. The court, this is at page A163. The court finds that Mr. Gamer's payment of $100 a month was not a bona fide effort to make restitution.
That's correct, Your Honor. And certainly, in this particular instance, finding that the defendant was able to pay in 2013 would have been completely unwarranted. I think it's worth noting that he was apparently unable to come up with $25,000, which was approximately 10% of the $227,000 restitution order, in order to avoid going to jail. So I would submit that a finding that he, in 2013, 3 years later, after 3 years of incarceration, had $227,000 stashed away would be absurd. And frankly, there's no evidence to that effect. The defendant testified he had no resources, no bank accounts, no real property, no rental property, and there's no evidence contradicting that. And there's certainly no.
So, sorry, if I could just ask you again, just to make sure we're clear on what the standard of review is. If the court made the willfulness finding, are we doing anything other than determining whether that willful finding was clearly erroneous?
Your Honor, based on Parker, I'd submit that actually the willfulness finding is a legal conclusion, and not a factual one. I note on pages 449 to 450 of Parker a couple points where they say the evidence doesn't logically support the conclusion the defendant had the ability to pay, and on 450, to the extent the court's memorandum can be read as a finding the defendant failed to make sufficient bona fide efforts legally to acquire the resources, the evidence did not logically support that conclusion. That is a legal standard, not a factual one. A little further on in Parker, the court does note that whether the defendant made sufficient efforts and whether those are bona fide is a factual determination.
Right.
In any event, however, Your Honor, and under any standard, in this particular case, the trial court's conclusions were wrong. Whether you apply a legal standard to the willfulness finding, or whether you apply the factual standard to whether his efforts were sufficient and bona fide, those conclusions are wrong. In this particular instance, what the defendant did, and I apologize for looking down periodically, I'm timing myself in the absence of a little set of lights. There's not really a significant difference of opinion between the state and myself on the legal standard here. This is largely a question of the interpretation of the facts in this case and the court's ultimate conclusions. In this particular instance, the defendant got out of jail in 2013. He was a 57-year-old man with a felony conviction. In and of itself, being a 57-year-old man with 3 years of no employment history, this in of itself would have rendered it fairly significantly difficult to obtain employment, but the felony conviction rendered it far harder. He was also confronted with a $227,000 obligation at that point. At that point, the defendant engaged in an extensive job search. This is detailed in the second sentencing memorandum. He filed over 270 applications in his first year.
Let me ask you a question about that second sentencing memorandum where it showed that he filed 270 applications. That information was provided to the court after the court had made the willfulness finding at the first hearing when the court determined that he had violated his probation, right?
That's correct, Your Honor.
So the court considered that information like a court would at any sentencing, even though it might not be admissible. And the state never had an opportunity to examine Mr. Gamer about those efforts or challenge that evidence in any way. Is that fair?
I don't think that's fair, Your Honor. Mr.
Okay.
Gamer testified at the hearing as to his efforts on job searches. He testified that he'd filed numerous applications, that he'd had 30 to 35 interviews, that he'd
Yeah, no,
interviewed.
no, I'm talking about the
I-
particular documents
Hmm.
that were submitted with the second sentencing memorandum at the sentencing hearing. Those, as to those documents, the state never had an opportunity to challenge those documents or inquire regarding those particular documents.
The state did not, Your Honor. However, there's a couple of points to be made in response to that. The first is that at sentencing, many things are admissible and are brought in for the first time. Hearsay is admissible at sentencing. Charges upon which the defendant was acquitted or mistried are admissible at sentencing as
Yeah,
consideration.
no, I completely agree with you about that, but that's kind of the question I have, which is when that information is considered at the sentencing part, can you now use that as evidence of non-willfulness that was decided kind of during the guilt phase?
Absolutely, and beyond dispute. What's more, Your Honor, you can certainly use it in conjunction with the Bearden standard, which has been in existence for almost 40 years, and which the trial court should have been applying in this particular instance in determining whether there was an alternative sanction available, whether incarceration was the only possible conclusion.
Right. Now that goes to that part. I understand that. But my question, when you say absolutely and without dispute, the court could consider the information submitted at the sentencing phase to revisit the willfulness determination when it found a violation of probation. Is there authority for that proposition?
I do not have any, Your Honor.
Okay.
The trial court did, in fact, take the information into account. And in consequence, I'd suggest that to some degree, it's the law of the case. The state hasn't challenged the trial court's taking that into account on appeal, has not argued as an alternative grounds for affirmance that the trial court should not have considered that material. It certainly did object to it at sentencing. However, Your Honor, I'm willing to posit that even if we take that material out of the court's consideration, the trial court's conclusion is unwarranted here. The state acknowledges that it is the burden of proving willfulness. At trial, at the VOP, the defendant testified he'd filed numerous applications, that he'd had 30 to 35 interviews in his first year alone, that he had applied to Home Depot, which is one of the places the trial court takes him to task for not applying to. So that particular conclusion is clearly erroneous. The defendant also testified that the only job he could find was the job he currently has or currently had at the time of at the VOP hearing, the job as a landscaper. It's hardly surprising that an individual with a serious felony conviction should wind up doing manual labor. That's where most of our clients wind up. It's a simple function of those are the people who are willing to hire somebody with a serious felony record. But the defendant testified beyond that he actually sought out to improve his educational qualifications in order to improve his employability.
Can I ask you a question about the educational opportunities?
Sure.
So the arguments, and I haven't viewed the entire transcript yet of the testimony, but it sounds like he borrowed $15,000 or somewhere between $11,000 and $20,000. It's unclear to me, to pay for that doctorate program. And then did he pay that back? Did he pay off the loan?
It's somewhat contradictory within the transcript, Your Honor. The defendant testified that he was not out of pocket on it. I believe the state is correct in saying that he also testified it had been paid back, but I'm not clear about the source.
Okay.
The defendant also testified that he had made attempts to get a loan. I'd suggest that asking someone to get a loan in order to pay restitution is unwarranted. However,
Bearden says that you can require someone to do that, right?
right. But the defendant did testify that he tried to get a loan from credit cards and that he did, in fact, obtain a loan from friends and family, and that $10,000, which was being held in escrow at the time of the VOP hearing, was all he could actually afford. Under these circumstances, the defendant has tried to get a loan from any place he could reasonably be expected to get a loan. And I'd suggest that his conclusion, which I think the state doesn't share, that he could get a loan through a bank by walking in and, hi, I'm a 57-year-old man with a 2-year work history at $30,000. I want to borrow $220,000 in unsecured capital. And by the way, I have a felony conviction for defrauding a bank. I think his point that that's unlikely to succeed was very well taken. Now, the state and the trial court both fault the defendant for not applying for minimum wage jobs. I'd point out that 40 hours a week at minimum wage job is not going to earn him what he, thank you, Your Honor, what he'd indicated he was earning from the landscaping company, which appears to have been a year-round position. But even if he had taken such a position, he would have fallen far, far short of the $220,000 restitution. Rather, his efforts toward finding more permanent employment appear to be focused on obtaining a job north of $100,000, which would have enabled him to pay the restitution. You know, I realize I'm running short on time, but the court case I'd refer this court to, because I find no Connecticut case involving such an extraordinary amount of restitution. I'd refer this court to the Court of Appeals case from Kansas cited in our reply brief in Heron. Heron talks about whether a plan of restitution is workable. There was no workable restitution plan here. There was no reasonable possibility that the defendant could pay $6,000 a month. And there was no reasonable possibility. I recognize I'm running over my time a little bit, but I did want to make this final point. There was no reasonable possibility the defendant could ever have made this payment. He was essentially doomed from the start. Under these circumstances, Bearden dictates that some alternative sanction would have been more appropriate. If there are no further questions from the court, I will save my remaining time for rebuttal.
All right. You'll have, we'll leave you with 5 minutes for rebuttal. Attorney Feldman?
May it please the court, can your honors hear me?
Yes.
Thank you. This is Lori Feldman, Deputy Assistant State's Attorney representing the people of the state of Connecticut. Your honors, the defendant diverts his argument to the irrelevant question of whether he could pay over $200,000, the amount he stole, in restitution, what the defense counsel just called an extraordinary amount of restitution. That is not the constitutional question under Bearden, and that is not the question on which the trial court ruled in this case. The state had the burden of showing, and it did show, that the defendant willfully failed to make bona fide efforts to pay what he reasonably could toward his debt to the victims and to society. In other words, the question was, did the $2,100 that the defendant paid over 6 years from the beginning of his probation until the VOP hearing reflect true acceptance of responsibility and his best efforts to repay his debt? This is a factual question in the trial court, that it's the trial court's role to make. The trial court expressly found that the defendant willfully failed to make best efforts toward paying his restitution, and the only question on review is whether the record reasonably supports this finding. And as to that question, I would quote from the Sentencing Review Court, which wrote, based upon a review of the full evidentiary record, it would be difficult, if not impossible, to reach any conclusion other than that the petitioner's failure to pay restitution was willful. And
what weight, if any, can we give to what the Sentencing Review Court said?
The Sentencing Review Court specified that its role was not to determine whether the willfulness finding was clearly erroneous, but I think that the fact that 3 judges found that it would be difficult, if not impossible, to reach a different conclusion is persuasive authority for the
So are
fact
you
that
saying
the
it would be
conclusion was.
appropriate for us to rely on the findings of the sentence review judges?
Your honors can independently review the record, and I think that you will reach the same conclusion. My point is that where the question of whether the factual finding was clearly erroneous depends on whether the record reasonably supports that finding, where 3 judges have found that it would be difficult to come to a different conclusion.
Yep. But I mean, it's still our obligation to do that analysis. And it seems to me that we have to disregard what those other 3 judges said. Otherwise, we're just abdicating our responsibility to that 3-judge panel.
I agree that your honors have an independent responsibility. As I said, I'm citing this sort of like out-of-state authority that may be persuasive, but certainly doesn't relieve you of your responsibility. In fulfilling your responsibility, however, you should not rely on the defendant's self-serving view of the evidence, and you certainly cannot rely, and it is completely inappropriate that the defense relies on the attachments to his sentencing memoranda. Those attachments were not evidence during the violation phase of the hearing. They were never introduced into evidence. They were not authenticated. There was no cross-examination on them. The trial court specifically said that it did not have them and therefore did not consider them, and that they weren't part of the evidence during the violation phase. And it is improper for the defense to try and rely on those unauthenticated documents that weren't before the trial court in claiming that the trial court came to the wrong conclusion during in making the willfulness finding. The defendant had his opportunity to present his evidence, and that was not part of the evidence, and therefore this court cannot rely on it. The admitted evidence and the trial court's opportunity to make credibility findings based on assessing the defendant's testimony and the other evidence fully support the trial court's finding of willfulness. And there were many, many pieces of evidence from which the trial court could infer willfulness. I would divide them into 2 overriding categories. One is the financial picture, the defendant's financial picture, and the other is the defendant's attitude, which in many ways evidence the fact that his failure to make greater payments than the, on average, $350 a year that he paid was a matter of attitude, not a matter of poverty. So with regard to his financial picture, I'm just going to pick a few points from the evidence. There are many. The trial court could fairly infer that he was not putting what he could toward restitution. As I indicated, his payment on average was $350 a year. During this period of time, he was living in a home at the cost of almost $3,000 a month. He obtained that, he was pursuing that doctorate degree where he somehow managed to take out and repay loans of approximately $20,000 while he was on probation. With no indication that that degree in any way tied into a greater chance of him getting a job, that no conversation with probation or any other indication that he had reason to think that this would make him employable and that he was doing this in order to repay restitution. He went on vacations. He paid every year the fees to keep his inactive company registered. And he very quickly amassed $23,500 to fight the violation of probation charges as soon as he faced the risk of going to jail for violation of probation, where he claimed that the same people, his family members who contributed that money, were not willing to pay $1 before the VOP charges toward helping him pay his restitution. He claimed that his living expenses, his vacation expenses, everything else were covered by other people, and he simply pitched in where he could. Either this is true, in which case everything that he earned over those years could have gone toward restitution, and perhaps those same benefactors could have helped pay his restitution, what he owed to society and to the victims, or it's not true, in which case he was lying about his financial picture. Either way, the trial court could reasonably infer that the defendant was not making best efforts. Even if he owned absolutely no assets, And the evidence suggested that he had, a number of vehicles registered in his name, and did own assets. But even if he owned none, he testified that he was earning $20 an hour landscaping, and yet his payments reflect, and again, I'm saying on average, 17 hours of work a year toward paying restitution. Yet he was going on vacations and he was living in a $3,000 a month home, but 17 hours of work a year toward paying restitution. He claimed that all of his expenses were covered by others. The trial court could reasonably infer that he could have put more toward restitution. He admitted that he set a cap in his own mind of $100 a month, many, many months, full years when he didn't meet that cap. But he admitted that that was the cap he set in his mind. And even if he had more money that he could have paid toward restitution, he didn't. This is a man who the evidence showed could have made much greater efforts toward paying restitution. And the whole category of evidence that points toward his attitude reinforces that and shows that the trial court's finding was not clearly erroneous. This court has already found historically, the trial court, the sentencing court, the guilty plea court, this court on appeal has found that this is a man who is playing games with the court system, trying to delay, trying to avoid, and that comes up over and over again in terms of his failure to pay restitution. For example, he continuously raised the pretext that the amount of restitution was the issue. He began his testimony in the hearing by claiming that he didn't owe the restitution because the amount of restitution, quote, came out of nowhere. This years of procedural history showed that this amount reflected what he had stolen from his mother and from his doctor. And when it was convenient, he admitted to this amount. For example, when he wanted to plead guilty, he admitted during the canvass that this amount was approximately correct. Or when he wanted to begin his probation, rather than remaining incarcerated, he signed the conditions of probation, agreeing that he would owe this amount. And yet he repeatedly attacked the number when it suited his purposes of delay and avoidance, while never attempting to show what the correct number was, or making serious efforts toward paying whatever that correct number was, which was certainly closer to $200,000 than to $2,100. The defendant during his testimony admitted that he didn't think he should have to pay restitution, and his testimony suggested that he was angry that the probation was violated just before it was about to end, which supports the trial court's finding that he was paying as little as he possibly could get away with in the hopes that he could delay until his probation would expire and he would not be accountable for the rest of the money for repaying the rest of the money that he had stolen. He hid behind rationalizations for doing what he wanted rather than taking his responsibility seriously. For example, he was asked during the hearing what he discussed with the Office of Adult Probation about how he could fulfill his obligation and earn more money. And his response during the hearing was to say that all the Office of Probation really wants is that you show that you're not going to just, quote, sit on your thumbs. And therefore, he decided to pursue his degree in foreign affairs online, called a Doctorate of Business Administration, which he made a point of saying is common in Europe. And so he took out that $20,000 in student loans and repaid that during probation without, again, showing any connection to the possibility that this would really make him employable and that he was doing this in order to repay restitution. The trial court could discredit his claim that the Office of Adult Probation, that he thought the Office of Adult Probation wanted him to be pursuing this degree rather than spending his time making whatever money he could and paying it toward restitution. The defendant played games with the Office of Adult Probation. For example, when, as a last resort, the chief probation officer took over his case for non-payment of restitution and told him to provide certain financial documents, rather than providing those financial documents, the defendant gave him some court transcripts. Now, this man with a doctorate in business administration certainly knows the difference between financial documents and court transcripts of his guilty plea. This was typical of his pattern of obfuscating and creating confusion rather than dealing in honest, good faith, bona fide efforts with the Office of Adult Probation. When Probation Officer Gordon told him that the time was running out and that he was not fulfilling his responsibility and indicated that Officer Gordon was going to need to pull the plug on this, the defendant told him, no, I'm getting a loan. I'm talking to my lawyer. This will take me 3 or 4 weeks, and then I will be back in touch with you about my loan. Now, this was the defendant's claim that he could get a loan to repay restitution. This is not the state's idea. This was the defendant's pretense for making Officer Gordon think that he was really pursuing a way of paying his restitution. And so Officer Gordon did wait 3 months before filing the warrant for a violation of probation because the defendant had said that he was going to take these steps and would be back in touch. However, the defendant did not get back in touch. And as far as Officer Gordon knew, the defendant made no efforts toward getting a loan. This, the trial court could reasonably find, was another delay technique to run out the clock and not have to pay the restitution. Your Honors, the trial court reasonably found that the defendant willfully failed to make bona fide efforts toward paying his restitution. With regard to the disposition of revoking probation and incarcerating the defendant, this was not an abuse of discretion, as the defense argues. Bearden sets forth the state's legitimate interest in incarcerating those who fail to make bona fide efforts to repay their debt to society and to the victims. And the trial court rightly found offensive the argument that the defense raises again on appeal, which is that he should not be penalized for his failure to pay because there was no victim or because other entities such as the bank or the bank's insurer can bear the costs of his crimes. This reflects his attitude, which has been prevalent throughout the proceedings, that someone else should pay for his wrongdoing and he should not pay a price.
Attorney Feldman, could the court have extended the period of probation?
I believe that is an option, but the trial court could rightly conclude that that would not serve any purpose because the defendant had shown over such a long period of time in his meetings with the probation officers month after month, in his sort of final ultimatum, in his response to the final ultimatum from the chief probation officer and creating this pretext and not following through on it, the court could find that this was a man for whom probation was not serving its purposes. This was a man who did not believe that he owed this money, as he testified at the hearing. This was a man who, given more time, that would just play into his purposes of delay and avoidance, and that it would not rehabilitate, the goals of rehabilitation would not be served. So that's a question in the trial court's discretion. The trial court did not abuse its discretion by determining that the defendant's willful failure indicated that probation was not serving its purposes, and his attitude indicated that he would play games rather than take advantage of the opportunity that probation would offer. This case involves the defendant intentionally perpetrating crimes for his own enrichment. He's responsible for making that right, and being unwilling to do so, he is not entitled to the benefit of probation. And finally, the defense brief suggests that the length of his sentence is disproportionate. That's a matter for sentencing review, not for this court. And that has occurred. And again, as the sentencing review court wrote, taking into consideration the serious nature of the petitioner's willful refusal to take meaningful steps toward complying with this important condition of probation, the sentence imposed is neither inappropriate nor disproportionate. If this court has no further questions, the state respectfully requests that this court affirm the judgment of the trial court. Thank you, Your Honor.
No further questions. Thank you. Attorney Streeter, you have 5 minutes for your rebuttal.
Thank you, Your Honor. As your honors probably picked up from our reply brief, the state and I have some considerable differences of opinion on the facts here. I'm not going to go through them all in detail because I only have 5 minutes, but it would refer the court to my reply brief on anything I don't make. The more important consideration is the state began her argument by noting the legal standard as what the defendant reasonably could pay. That's not the legal standard. The legal standard, as put forth in Parker and cited to Bearden, is whether the defendant had the ability to pay and willfully chose not to, or did he not have the ability to pay and fail to make sufficiently bona fide efforts legally to acquire the resources to pay. I'll admit the difference is subtle, but it is there, and it is very concrete in this particular instance. The state has made no serious argument that the defendant had $227,000 in 2013, nor could any be made from the facts that were introduced. Rather, the state has focused on the defendant's attitude that he shouldn't have to pay restitution. The defendant acknowledged he felt he shouldn't have to pay restitution, and the sentencing transcript does indicate there was another side to this story. However, he acknowledged that he did have to pay it and that he was required to. All of the things that the state cites as examples of a somehow luxurious lifestyle in a couple that does not go out to eat and doesn't go to the movies and lives in a very small house in Stanford, the defendant testified were paid for either by his wife or were functionally free as paid for by other people.
Attorney Schrader, could you explain his wife runs a catering business, right?
Correct. That's correct, Your Honor.
And he claimed that he wasn't qualified to work for a catering business. Is that what his testimony was?
His testimony was he doesn't have the necessary skills for the high-end catering that his wife does. It does require certain numbers of skills to serve as a waiter or an individual of that nature.
I don't know. I mean, I think a lot of us did that when we were in high school or college.
Yeah, you waited at five-star restaurants. I don't get to ask questions, but I didn't wait at five-star restaurants, Your Honor. I waited at Dunkin' Donuts, and those jobs pay $10 an hour, which on a yearly basis amounts to less than he was making as a landscaper. I did want to refer the court, because I think it's germane, to something the state said about this and something Your Honor had questioned. I'd refer the court to page 12 of my brief. A willfulness inquiry requires review of the whole record. The whole record in this case includes that second sentencing memorandum. And in consequence, this court's standard would include that document. I would note that the state comments on the defendant having talked to people in his family to come up with $23,500 to fight the VOP. I find it a little disconcerting that the defendant's borrowing money to pay legal fees is being considered as some evidence of recalcitrance. But in any case, what the state's included in that $23,500 is $10,000, which was being held in escrow at the time of the VOP for repayment of restitution.
Well, why was it held in escrow and not just paid towards restitution?
I think they were trying to negotiate a deal in some kind of good faith effort that fell apart. But that particular,
I want to ask you the same question I asked Attorney Feldman, which was, could the court have put the defendant, could have court have extended the defendant's probation, or was it at its statutory limit?
As I sit here, Your Honor, I don't know the answer to that. I have no reason to dispute that the court could have extended the defendant's probation or put some other constraints on him. What was uncontroverted below was that the bank would have a civil judgment against the defendant and that would run for 20 years. It's my recollection, and I haven't done the research on this, that that's non-dischargeable in bankruptcy. So the bank is getting its money if the defendant ever emerges from his current financial situation one way or the other.
Well, the difference, though, is that with probation, he has an obligation to use bona fide efforts to get the money, whereas for a civil judgment, he doesn't have those any obligation to do anything. You just say, I never got the money, so therefore you can't collect from it.
I'm not sure. Do I have time to answer Your Honor's question?
Yeah, please, go ahead.
But there are other constraints on a civil judgment that might be applicable, Your Honor. They could attach his wages. They could garnish any bank accounts. I don't know that you can attach Social Security, but, you know, and we're getting, with a 63-year-old man, we're getting close to that. But you can certainly pull him into court and on a capias if necessary. There are certainly remedies that can be extended by the bank in order to collect some or all of their debt. You know, I take some issue with the fact that, you know, the state's contending we're not saying the bank is a victim. Certainly the bank is a victim in this case, but certainly they're not the major victim, and they're not a major crime victim, and they're not the complainant here. Thank you, Ron.
Thank you both. I appreciate you doing this through the Teams platform and being as professional in this as you both are when you're in court. We will take the matter under advisement. As I mentioned, Judge Pellegrino will review this argument in addition to all the other materials, and then we will decide the case. Have a good day and stay safe.
Thank you. You too, Your Honor.